March 12th. This morning, the court issued its ruling on 3 motions, the most important of which was whether the false imprisonment charge survived the defense motion to dismiss. The legal standard is whether, in the light most favorable to the state, the evidence proves beyond a reasonable doubt that the defendant falsely imprisoned Teresa Halbach. The state is not just entitled to the evidence, but any inferences that could be reasonably drawn from the evidence. We lost the false imprisonment count. Although the court found that the state's theory the victim was lured to the house was reasonable, there was no physical evidence that she was confined or restrained, and the jury would need to speculate about that fact. The other 2 motions were won by the state. First, the court reaffirmed its ruling that the execution of the search warrant, especially as it pertained to the burn pit area, was reasonable. In pretrial rulings, the court had already denied the defense complaint about the multiple executions of the warrant. But second, the court denied a defense motion to exclude the bullets in the case, as they complained that they did not get to watch over the DNA analysis and that the analyst consumed all of the sample. It was a pretty easy motion for the court to reject. After the rulings, the defendant was asked whether he intended to testify. I'd been preparing for his cross-examination, including the entire previous weekend, and was prepared with not just statements he made to law enforcement, but statements he made to media and statements he made during recorded jail calls. As previously decided by me in the case, I did not put any of his previous statements into evidence. I had all of his contradictory statements held back and ready to impeach him should he have chosen to testify. He decided not to testify, which was the outcome that I predicted when I didn't give the defense a chance earlier in the case to get in any of his denials in through any of my own witnesses. The defense rested. The state had no rebuttal testimony to present, as the defense was a couple of citizens who didn't recall anything and 2 experts who disagreed with our experts. So, the evidentiary part of the case ended abruptly, and the defense requested a whole day to prepare their closing argument, which we would talk about instructions on Tuesday the 13th and give our closings on Wednesday the 14th.
This is John Lee with Gannett, Wisconsin newspapers with an update from the Steven Avery homicide trial. The defense is expected to wrap up its case today. The day started with Judge Patrick Willis dismissing the false imprisonment charge against Steven Avery. Willis said there was not sufficient evidence presented to show that Teresa Halbach was taken against her will, and said that determining guilt or innocence on that charge would require the jury to make a leap of conclusion and not base their decision on evidence.
The court concludes there is not sufficient evidence in the record to support a jury finding of guilt beyond a reasonable doubt on the false imprisonment charge, and the court therefore grants the defendant's motion to dismiss that charge.
Judge Willis decided not to throw out the search warrants as being overly broad from the week of November 5th through the 12th at the Avery salvage yard. And he also rejected a defense motion to throw out evidence from the bullet fragment that was found in Avery's garage and found to have Teresa Halbach's DNA on it.
The defendant in this case has a right to testify if he wishes, and the court wants to make sure that if he is declining to exercise that right, that it's done so knowingly and voluntarily. Mr. Strang, have you raised this issue with your client?
I have raised it with Mr. Avery, that is, Mr. Buting and I both have jointly several times, probably beginning before trial and then during trial.
Thank you. You can move the microphone over to Mr. Avery then. Mr. Avery, do you understand that you have a constitutional right to testify in this case if you wish?
Yes, I do.
And do you further understand that you have a constitutional right not to testify if you wish?
Yes, I do.
Do you understand that the decision whether to testify or not is yours to make?
Yes.
That means you can listen to your attorneys and listen to their advice, but ultimately it's your call. Do you understand that?
Yes, I do.
Has anyone made any threats or promises to you to influence your decision?
No, they didn't.
Have you thoroughly discussed your decision with your attorneys?
Yes, I did.
And have you made a decision as to whether or not you wish to testify in this case?
Yes.
What is your decision?
The decision is I'm an innocent man, and there's no reason for me to testify. Everybody knows I'm innocent.
Okay. So you wish not to testify, is that correct?
Yes.
Thank you. You may be seated.
Thank you.
Rested its case Monday afternoon, and Special Prosecutor Ken Kratz said he was not calling any rebuttal witnesses.
Your Honor, Mr. Buting and I jointly have elected to rest at this time on behalf of Steven Avery.
Judge Willis gave the jury Tuesday off and said attorneys would be working on jury instructions and closing arguments. We're not sure if they will be in court or not Tuesday. If there's disagreement on jury instructions, they may go on the record. There are also a couple questions about jurors and if they've successfully avoided discussion or media information on the case. We'll be here and there will be updates. Join us again Tuesday at postcrescent.com or wisinfo.com, and again Wednesday when the closing arguments and the case goes to the jury.
March 13th. The defense had tried unsuccessfully earlier in the trial to remove a female juror who had previously sat on a civil case involving Detective Dave Remacher. She's been very attentive, and the state would hate to lose a good juror. So, before coming to any agreements with the defense on what jurors would hear the case, we made the defense unsuccessfully argue again for the juror's removal for cause. We toyed with the idea of each side being granted another preemptory strike, as we wanted to remove a male juror whose occupation was being in a band and living on his wife's trust fund. But late in the day, the judge got word that some citizen overheard a juror at a fish fry express her opinion that the defendant was guilty. This causes great appellate concern, especially if she's not struck for cause, and later it was determined that the story was true, so we were trying to ensure the best jury makeup while avoiding any appellate issues at the same time. We all questioned the juror in the morning.
This is John Lee with an update from outside the Calumet County Courthouse on the Steven Avery homicide trial. Judge Patrick Willis ruled this afternoon that he will allow the jury to hear an instruction allowing them to consider the allegation of planted evidence. The judge ruled after a hearing this afternoon that there was enough testimony given in the last 4 weeks to allow that evidence to be presented to the jury. The jury pool will remain at 15 going into closing arguments tomorrow morning. Judge Willis has again rejected a defense motion that a juror who identified Manitowoc County Detective Dave Remacher as the plaintiff in a lawsuit 8 years ago when she served on a civil jury is not biased and will remain in the pool.
But now that it's out, now that we know something more about the 1999 civil case involving Detective Remacher, I think she should be relieved of further duties on the grounds of objective bias.
Does the state wish to be heard?
We would oppose the striking for cause or the excuse of this juror. We're going to begin with
our presentation with the law. A prospective juror is objectively biased if a reasonable person in the prospective juror's position objectively could not judge the case in a fair and impartial manner.
There's questions on a couple others that may change later today, but otherwise 3 of those jurors will be named alternates when jury deliberations begin tomorrow. Attorneys expect jury instructions, then closing arguments tomorrow with the case going to the jury somewhere in mid or late afternoon. Stay tuned to your Gannett, Wisconsin newspaper, Post-Cresent.com, for updates from the Steven Avery homicide trial.
I had been working on my closing argument to some degree since the weekend. The tone and the structure were not chosen randomly. First, I decided to not talk about Lieutenant Link and Sergeant Colburn. I knew the defense had to attack them in their closing, and saving the topic for my rebuttal argument would likely allow me a more indignant tone, which would be in sharp contrast to my natural style and the tone that I purposely had selected for my closing. Second, rather than trying to inject a lot of sympathy into the argument, which would be easy given the subject matter and the type of murder victim we were talking about, I decided to stick to the facts of the case, a concept that Norm Gahn called "hit them over the head with the facts." My closing, like my opening, was presented using PowerPoint slides. For the last 15 months, I've been putting all the photos in the case into a laptop computer, organizing them, allowing witnesses to view them, but also use them in my arguments. I was proud of my ability to present visual evidence, and I hope that this trial had shown the jury the extent to which I was prepared. I didn't fumble around with photos, documents, or other exhibits. The defense had asked me on several occasions to put an exhibit up on the screen for them, or generally to be accommodating. But frankly, I've spent a great deal of my time and energy organizing these images, and the defense shouldn't be reaping the benefit of my work product. My closing was organized by fact numbers, that is, fact number 1, fact number 2, etc. These facts were meant to include most of the uncontested facts of the case and showed the jury that all of the evidence pointed to the same conclusion, that Steven Avery was responsible for the murder of Teresa Halbach, and by inference her mutilation of her corpse and possessing a firearm as a convicted felon. I organized my closing by topic for a couple other practical reasons. First, since the judge had dismissed the false imprisonment count, the charge which required the jury draw some inferences from the hard scientific and eyewitness evidence, I no longer had a compelling reason to tell a story to the jury with my closing. In other words, if I had to convince the jury to assume fact that supported the false imprisonment count, I would have had to have told the story in a narrative fashion. Since I no longer had such an obligation, a topical closing argument structure made more sense. The last reason I picked a topic-oriented closing was the sheer volume of information I was asking the jury to digest. There had to be some organization that every educational level juror could grasp, especially since they were not allowed to take any notes during the closing. Throughout the trial, I had Julie Leverins, my victim witness coordinator, taking pictures of witnesses for a reminder to the jurors what the witness looked like, so they could place their testimony within their memories. The one disadvantage to a topical closing was the reality that any single witness may have offered evidence on more than one topic, and therefore their photo was going to be used several times throughout the closing. But there wasn't anything I could do about that, and the benefits, including the photos of the witnesses with their bullet points of what they said, far outweighed any redundancy or using the same witnessed photo. In writing my closing, and eventually in its delivery, I had to choose a point to start the closing. Because of the overwhelming size of the investigation, I theorized that I needed the jury to pick one moment in time and build both forward and backward from that moment. If I could place the jury in that one moment, I'd be well on my way to breaking the closing into smaller bite-sized pieces for them to then chew on. The question, of course, was what moment did I want to start at? I thought for the past year that I would be giving a tell-a-story closing, so the story needed a starting place too. Frankly, my original thought was to start at the very moment when Teresa was shot by Steven Avery. That was a focal point of the investigation, and by its very definition, the central allegation, murder, made against Avery. My original closing themes were going to include the 5 senses. The sound of the .22 caliber rifle being the last sound that Teresa ever heard. It was going to be my launching off point. It was a moment in time. It allowed discussion of physical evidence recovered. It would evoke emotion with the jury. It would also grab the immediate attention, and that would be the beginning point. The problem with that start, however, was it was not an uncontested fact. It didn't fit my new hit them over the head with the facts theme. Therefore, I was searching for another moment. One probably less dramatic, ironically, was also a better option in my opinion. I could start with 8:12 a.m. on October 31st, 2005, the moment Steven Avery called Auto Trader and asked that Teresa be sent out to his property. That had the advantage of being relatively uncontested, but it didn't really allow too much mobility going forward and backwards in my arguments. It also wasn't very dramatic. A phone call rarely is, and I didn't think that would grab the jurors' attention sufficiently. My next thought was to start with 7:45 p.m. on Halloween night, the moment in time when Scott Taddock sees Steven Avery and Brendan Dassey standing next to the big fire behind his garage. It had the advantage of being relatively uncontested, was a pretty striking image the jury could see in their mind's eye, and was late enough in the story to go back and forth with. The problem, it had more to do with the lesser count of mutilating a corpse than that of the first-degree murder count. I didn't want to start with the lesser of the 2 important charges. I needed a moment in time that changed the investigation and changed people's lives. So I settled on the moment when Pam Stern found Teresa's SUV on the Avery salvage property. It was a specific moment in time. It was without controversy or contest, and it was dramatic. At least, it changed this case from a missing persons case to a criminal investigation. It was right in the middle of the story, after all of Steven Avery's actions could be argued and before the law enforcement investigation began in earnest. So, fact number 1 for the jury was the victim's SUV. I chose not to replay the dramatic phone call that accompanied the discovery of the SUV, mostly due to time constraints and the initial confusion as to whether the SUV was blue or green. But I think it represented a very good fact to start the closing with.